The preamble is based on the Objectives Resolution, which was drafted and moved in the Constituent Assembly by Jawaharlal Nehru on 13 December 1946 and adopted by Constituent Assembly on 22 January 1947. The preamble can also be called the soul of the Constitution as it has everything about the Constitution. It was adopted on 26 November 1949 and it was started from 26 January 1950, also known as the Republic Day. The preamble to the Constitution of India is a brief introductory statement that sets out guidelines to guide people of the nation, to present the principles of the Constitution, to indicate the source from which the document derives its authority and meaning. It reflects the hopes and aspirations of the people. The preamble was amended only once on 18 December 1976, with most of the opposition being jailed during the emergency in India. The Indira Gandhi government pushed through several changes in the 42 Amendment of the Constitution. Through this amendment, the words socialist and secular were added between the words sovereign and democratic, and the words unity of the nation were changed to unity and integrity of the nation. There are 9 keywords in preamble. 1. Sovereign. 2. Socialist. 3. Secular. 4. Democratic. 5. Republic. 6. Justice. 7. Liberty. 8. Equality. 9. Fraternity. Sovereign. The term means that India has its own independent authority and it is not a dominion of any other external power. In the country, the legislature has the power to make laws which are subject to certain limitations. Socialist. The term means the achievement of socialist ends through democratic. It means it holds faith in a mixed economy where both private and public sectors coexist side by side. It was added in the preamble by 42nd Constitutional Amendment in 1976. Secular. The term means that all the religions in India get equal respect, protection and support from the state. It was also incorporated in 42nd Constitutional Amendment. Democratic. The term implies that the Constitution of India has an established form of constitution which gets its authority from the will of the people expressed in an election. Republic. The term indicates that the head of the state is elected by the people. In India, the President of India is the elected head of the state. Justice. It is necessary to maintain order in society that is promised through various provisions of fundamental rights and directive principles of state policy provided by the Constitution of India. It comprises 3 elements, which is social, economic, and political. Liberty. The term liberty means freedom for the people to choose their way of life, have political views and behavior in society. Liberty does not mean freedom to do anything. A person can do anything but in the limit set by the law. Equality. It refers that all human beings are equal in all aspects because they are equal by birth as a human being. And everybody should be equally educated, wealthy, and equal status in the society. Fraternity. It means the sense or spirit of brotherhood that promotes unity and integrity in the nation and binds its people. It stands for standing up for fellow citizens and to resolve dispute and conflicts in well-behaved and orderly manner that would not harm the integrity of the nation. Berubari Union case in 1960, at the time of partition of India and Pakistan, Sir Radcliffe distributed thanas between India and Pakistan. There was this thana, Berubari, in Jalpaiguri district of West Bengal. Radcliffe awarded it to India, but unfortunately it was not mentioned in the written text of the award. This gave opportunity to Pakistan to claim on Berubari, citing a reason that Berubari falls in the map of Pakistan. Dispute continued till Nehru-Noon Agreement was signed in 1958 between India and Pakistan. In the agreement, the territory of Berubari Union was divided and distributed equally between India and Pakistan. But Supreme Court said Article 3 is not sufficient power to diminish state territory. Then Supreme Court Article 3 was changed by powers of the Article 368 on the date of March 14 in 1960. It was decided by a bench of 7 judges. In this case the Supreme Court said that the preamble is not a part of the Constitution, and because of this example, and it also added that the preamble has no substantive power.